since the individual stole my intellectual property
The worst.
as a designer, despite having voided contract due to non-payment. Uh-oh. So ex-employee gone wild here. What do you do?
So yeah, I mean, it sounds like potentially, and I run into this situation pretty often.
Okay.
Client will hire a logo designer, someone to do graphic design for them. They'll do it, right? And then, ultimately there'll be disagreement between the parties, and the one party will say, hey, you don't actually own this. I designed it. I didn't assign it to you. And that's a big thing in like the art design world, is like copyright protection, right? Like, I'm an artist, I own my own copyrights.
Yep.
And that's all well and good. But when it comes to commercial, doing work for other people, I mean, honestly, like, that should be a work made for hire agreement. So I would say, if you have, it's gonna be a state level question, to be totally honest, but if you have some sort of contract between the parties, I'd want to see that contract. There's going to be a clause in there about what happens if that contract is, voided, or I guess infringed upon, right? Violated. At that point, right, you could still have the rights to the trademark or the logo, or potentially the designer has it. But I guess without more context, really hard to say.
Hard to say. Hire a trademark attorney. But in this case, what you're saying is this likely is a situation where an individual hired somebody, a designer, to go make art,
Yep.
a logo, if you will, and then didn't pay them. Obviously, screwed them, avoided the contract, and then took it and used it to register a trademark.
Yep.
Does the artist have any recourse? Looks like perhaps in state court, you're saying copyright, or a federal court copyright infringement, maybe. But it's going to depend on whether the initial work counted as a work made for hire, and then it's just a matter of going after damages for the payment.
Right. Yeah. I mean, I guess you could challenge this at the USPTO if they truly did file a trademark registration. But I mean, the USPTO does not want to litigate work made for hire agreements. That's not what they're into, right? At the end of the day, they want to see who had priority of the trademark first, and that's really it. But yeah, they don't want to deal with this. So this is a state level trademark question, I would say.